well?
Your Honor, this is my motion for summary disposition on behalf of Secura. As you know, this is a declaratory judgment action in which I have requested 3 declarations. The first being a declaration that Secura has no duty under the policy, the commercial liability policy that I've attached to my motion and the complaint, to defend their insureds, Todd and Christy Schauman and North Fork Farms, in the underlying case, the underlying tort case filed by Ashley Bertle, who was also a defendant in this case. The second declaration that I am seeking is a declaration that Secura may withdraw from participation in the defense of the underlying case immediately and stop paying defense costs. And then the third declaration that I am seeking is a declaration that the insureds, Mr. and Ms. Schauman and North Fork Farms, be required to reimburse Secura for the attorney's fees, costs, and expenses it incurred while defending them against the underlying case pursuant to this reservation letter. Now, I know that the court has read everything, so I'm going to be very focused in my presentation. The underlying case arises out of a July 2018 incident in which Todd Schauerman allegedly grabbed Ashley Bertle's hair, spun her around as she was trimming a horse's mane, and threatened her with some scissors. This incident occurs while Ms. Bertle is actually employed by North Fork Farms. That incident has led to the underlying lawsuit, which essentially focuses on that incident, then focuses on a series of allegedly defamatory statements that the Schauermans made about Ms. Bertle. And then there are these wage claims and Elliott Larson claims orbiting about as well. There are a number of causes of action in the complaint: battery, assault, false imprisonment, intentional infliction of emotional distress, negligence, premises liability, wage and claim hour claims, and a Bullard, Pullicky, and an Employee Right to Know Act. Now, like I said, Secura has been defending this underlying case under a reservation. There are a whole spectrum of different problems with coverage for this. None of these alleged acts constitute an occurrence under the bodily injury and property damage section of the policy, including the wage claims and the discrimination claims. The line of cases that I cited in my briefing, the Burchell and Smorch line of cases, stand for the proposition that you can't rename something, you can't name an assault negligence, or in this case, name an assault premises liability. You have to look at what the substance of the claim is itself. And if you do that in this case, you distill the underlying case down to those 3 things that I described: the incident pulling the hair, the defamation claims, and the excuse me, and the wage and hour claims, and the Bullard-Pullicky claims. There are a host of exclusions that apply: expected or intended exclusion, workers' compensation or similar law exclusions, the employer's liability exclusion relative to the personal and advertising injury coverage, which could capture defamation, knowing violation exclusion, criminal acts exclusion. There's an abuse or molestation exclusion on this policy. There's an assault and battery exclusion on this policy, and we've cited all of those for you and briefed them all. But really the most expeditious way to go about resolving coverage in this case is to look at the employment practices liability exclusion, which I cite at page 13 of my motion. That exclusion applies to both bodily injury and personal and advertising injury. And it stands for the proposition that if bodily injury or personal and advertising injury, which could include defamation, arise out of any of the various things described in the exclusion, there's just no coverage. And there's case law, not a lot in Michigan, believe it or not, but there's case law that I cite on pages 14 to 15, a great deal of case law, that stands for the proposition that this exclusion essentially defeats coverage for each and every claim in this complaint, and it would not even matter if some of the alleged defamatory statements, for example, were made after the employment relationship ended. The exclusion still applies. So principally on the basis of that exclusion, Your Honor, but on the basis of the occurrence arguments, The arguments relative to the lack of property damage in connection with the wage and hour claims, which are economic claims alone. There is simply no duty to defend or indemnify the underlying case. And I, on behalf of Secure, request the declarations that I outlined, those three, at the beginning of my argument. I'll answer any questions you might have.
I don't have any.
Okay, very good. Thanks, Judge.
Mr. Betts?
Your Honor, we did file a response to the motion. We filed a brief in support of the response. The first objection is this motion filed by Secura could have been filed at day one. There's nothing new in this. They knew everything that is in their current motion when they first received the demand for defense from my clients, the Showermans. So the timing to me is way off. If I understand Mr. Ryan's argument correctly, he's saying to this court, well, Ms. Bertle in her separate suit in this court has titles to her complaint, but don't look at those titles. We want you to try to figure out what happened behind the scenes, even though there's no deposition transcripts that would guide this court or other evidentiary evidence. All we have on this motion is, excuse me, police report, which we say cannot be admitted as being hearsay, and three unpublished Court of Appeals cases, the Byron Hall case, which talks about an eye injury to a developmentally disabled person in the care and custody of a facility called Social Resources Incorporated. Well, Ms. Bertle was not in the care or custody of my clients. She doesn't say that she was, so obviously that exclusion wouldn't apply. The third case that they cited in support of their motion was a case involving attorney Brian Daly. It's a requested rescission of a legal malpractice policy. Well, rescission is not an issue in the case before us. All we have is Secure Insurance saying we're denying your claim essentially for defense and coverage, but Secure has never said we want to rescind the policy. So I say there's no support for the cases that they have cited and attached to their motion or to their brief anyhow. We ask, I think the Michigan law is clear. If there's any theory by which the underlying plaintiff, Ms. Bertle, could succeed, my clients get coverage, and it's not this court's job to look at the merits of her case. This is what she claims, and you have a copy of her complaint. She filed 11 counts, 130 paragraphs, something like that. So we say, obviously, all we have to do is show that we have coverage under one, and the appellate cases say my clients get the benefit of the doubt. Should there be coverage? Should there not be coverage? The Showermans get the benefit of the doubt. So we say you have to deny the motion. Thank you, Your Honor.
All right, thank you. And Mr., I struggled with the pronunciation last time. You'll have to help me again.
No problem. It's Stratilatov, Your Honor.
Easy.
The phone.
Stratilatov.
That's right. Good afternoon, Your Honor. And, I'll make this brief as well. I'm sure you've had a chance to review our brief on this matter. One important issue that I would like to bring up with respect to the personal advertising injury coverage, Mr. Ryan refers to an exclusion which pertains to the defamatory statements in that coverage. However, the defamatory statements that we're alleging were said by Ms. Showerman were not pertaining to the alleged injury that Ms. Bertle suffered. Some of them pertain to her character and some of them pertain to her ability to run a business. At this point, Secure has not presented any documentary evidence to support their motion for summary disposition that there are no possibilities for coverage. In fact, we have deposition from my client, deposition from another individual, but no statements have been taken thus far on the record from the Showermans. Without this material evidence, there still could be issues of material fact that need to be addressed, namely with these defamatory claims, whether or not they were said with the knowledge of them being false, and could reveal potential coverage under the Secure policy. Do you have any questions?
No, thank you. I'll give Mr. Ryan rebuttal time if he
Just
wants it.
very brief. With regard to Mr. Betz's two arguments relative to asking you to divine the nature of the complaint, I'm not asking you to do that. I'm just asking you to apply the case law, the Smorch and Burchell line of cases that talk about when you try to figure out whether there's a duty to defend, looking at what's really being alleged and not what it's labeled, just as a mechanism to trigger coverage. First, with regard to the Daly case, that was actually my case. I have not requested that this policy be rescinded. We cited Daly for you only for the proposition that when a carrier reserves the right to seek reimbursement in its reservation letter, like I did in this one, that under Michigan law, that's recognized as a viable request to make. And then finally, I won't try to butcher counsel's name, I'm sorry.
Sure.
With regard to the argument that he made about the defamation, it does not matter whether or not the statements were made in good faith, were made innocently, were made with the belief that they were true. All the statements complained of arise out of this employment relationship, and the policy has that exclusion in it, as well as those other exclusions that orbit about it, the employer's liability, the workers' compensation exclusions, to make it clear that there is just no coverage when an employee of yours sues you for either a bodily injury or some sort of discrimination or harassment or defamation, all of which occurred in this case. And so for those reasons, Judge, and all the others that my motion mentions, I ask that you grant my motion.
All right, thank you. Well, thank you for keeping that very brief. It was a lot of briefing in this case, particularly by the moving party, but that's okay. It is rather complicated, mainly because the underlying action has 11 counts. But anyway, first of all, just to right up front address what Defendant Showerman said at the get-go, which is the timing is suspicious. Well, the defense was undertaken under a reservation of rights, so that puts everyone on notice that there may not actually be a duty to defend, and I don't see any basis for complaining about the time. I mean, I understand the complaint about the timing, but legally it doesn't make any difference here. Before we get into the rest of it, a little bit of law. The insurer has a duty to defend, and that duty, as Mr. Betts has alluded to, it's not limited to meritorious suits, and it may extend even to actions that are considered groundless, false, or fraudulent, so long as the allegations against the insured even arguably come within the policy coverage. And furthermore, an insured has a duty to defend despite theories of liability that are not covered under the policy if there's even one theory that falls under the policy. So you get one in, you get the duty to defend. And with that law in mind, and plenty of other law as well that applies to these duty to defend DEC actions, but essentially that's where we start off. Looking at the policy, coverage exists only where an occurrence has taken place, and the term occurrence is defined in the policy as an accident. The term, this is not at all uncommon, the term accident is not defined in the policy. However, I'm following Frankenmuth Mutual Insurance Company versus Masters, 460 MISH 105. 1999 case, and lots of other case law as well, where the term accident is not defined in the policy, so a common meaning of accident is employed. And the common meaning of accident is an undesigned contingency, a casualty, a happening by chance, something out of the usual course of things, unusual, fortuitous, not anticipated, and not naturally to be expected. So with that in mind, and turning to counts 1 through 4 of the complaint, which apply to defendant Todd Showerman only, these counts are based on allegations that Todd Showerman and I'll just summarize here. This is basically paragraphs 20 through 29 of the complaint. He approached the plaintiff, which in the underlying case is Ms. Bertle, from behind while she was standing on a bucket, grabbed her by her hair close to her scalp, pulled her down off the bucket by her hair, spun her around, still holding on to her hair. She said, "You're hurting me, please let go." Co-workers asked him to please let go. He did not. This is what's alleged. He then grabbed scissors from the plaintiff's or Ms. Bertle's hand and pointed them within a few inches of her face. While pointing the scissors at her, he shouted, "How would you like me to cut your effing hair?" And then he pointed the scissors at co-workers, made a similar statement while still holding Ms. Bertle by her hair. Again, he's asked to let Ms. Bertle go. He finally releases her, and she says, "You have no right to put your hands on me," and he says, "Shut the F up." So that's a summary of the underlying allegations. These are alleged as intentional acts, and they can only be described as intentional acts. They are certainly not undesigned contingencies or happenings by chance or fortuitous or not anticipated acts. The response to this from the Showerman defendants is that they say that all the facts relating to the hair grabbing incident haven't been established or resolved, and at least back when this was originally said, I don't know if this is still true, but Todd Showerman had not been deposed. And the Showerman defendants go on to say, and this is a quote from their response, "Assuming for the sake of discussion that it becomes established fact that Ms. Showerman," I think that's supposed to be Mr. Showerman, "touched Ms. Bertle's hair, the touching without more does not by itself establish an assault. It may well become established fact that Mr. Showerman had no intent or plan to injure Ms. Bertle, and that any consequences of the touching were accidental." And then, paren, accidental equals coverage. Well, accidental does equal coverage. However, the plaintiff responds that Todd Showerman's already made an admission that the hair pulling incident took place, and the discovery in the underlying case closed in June. I think those are both valid responses to the Showerman defendant's argument, but I would add the following. This is a C-10 motion. So if the facts have not been fully developed, where is the affidavit of Todd Showerman? Where is any evidentiary or other support? If facts haven't been fully developed, the non-moving party can't just say that hasn't been fully developed. They can't just claim that there's an issue of fact. Also, the Showerman defendants make no explanation of the rest of the hair pulling incident, even if the touching of the hair was not intended or was an accident of some sort. They make no explanation of the rest of the hair pulling incident and how it was unintended. Pulling her, and that is pulling her off the bucket, threatening her with the pair of scissors. And then the third thing I would say to the defendant Showerman's response is that even if an intentional touching was followed by unintended consequences, let's go back to the Frankenmuth case, because that's exactly what it was about. The guy in there, Masters, intentionally set a fire to a clothing store, intending to create a smoking fire that would damage the inventory. The fire grew beyond what was intended, and it damaged the building, and the court concluded that the consequences reasonably should have been expected, and said that it is irrelevant whether the harm that resulted, damage to the clothing store and surrounding businesses, was different from or exceeded the harm intended, end quote. And so it still didn't meet the definition of accident or occurrence. So you can't just explain away the initial act and say that was accidental when there's a sequence of following acts that no one has claimed were accidental, and say then that the whole thing is accidental and it includes coverage. So there simply is no coverage for counts 1 through 4. Even if it met the definition of bodily injury or accident, there is an intentional acts exclusion that you don't even have to get to, but it is there. And so counts 1 through 4 would be excluded. There's no coverage of any sort under any theory as to counts 1 through 4. And if there's no coverage, there's no duty to defend. So I'll turn next to count 5. Count 5 is a negligence count. It pertains to all defendants, and it alleges a failure to warn or protect, discipline, prevent, or refuse to hire Todd Showerman. This again is based on the same underlying facts as counts 1 through 4, and that's the intentional conduct by defendant Todd Showerman. The Showerman defendants simply say, well, count 5 is based on negligence and not intentional acts. And that is negligence of the other defendants, not Todd Showerman necessarily. Todd Showerman has an intentional act. The other defendants are based on negligence. But I'm going to follow Michigan Basic Property Insurance versus WASAROVICH, which is at 214 Mich. App 319, a 1997 case, where one insured committed an intentional act, a shooting, and another insured was sued for negligence in connection with the shooting. So just like what we have here, analogous to what we have here. The Court of Appeals said, our analysis should focus on the injury-causing act and must be analyzed from the standpoint of the insured and not the injured party, which is the same thing the Michigan Supreme Court said in Frankenmuth, by the way. Therefore, there was no accident or occurrence and no duty to defend the alleged negligent insured in the underlying action. The same analysis applies here to count 5. Focusing on the injury-causing act, that act is the intentional acts of Todd Showerman. That act, which is the basis of count 5, and tries to apply negligence to the remaining defendants, takes that act or that count out of coverage, even as to the non-intentionally acting defendants. That takes us to count 6, premises liability. And this is really based on the same intentional acts of defendant Todd Showerman. All it is, and again, I understand the law that you don't assess whether something has merit or not, but the court can and should look at whether something is just labeled in a way to try to get into coverage when really it's something else in disguise. And that's all count 6 premises liability is. It's a relabeling of counts 1 through 4 in the guise of a premises liability claim against all the defendants. And that is similar to the Smorch case, S-M-O-R-C-H, that the plaintiff cited, where the allegation was labeled negligence, but it was really an A and B, assault and battery in disguise to avoid the policy's intentional acts exclusion. So the court is supposed to look to the true nature of the claim. And here the premises liability claim is an assault and battery claim. Even aside from all of the above, the claims in counts 1 through 6 would fall under the policy exclusion for employment-related practices that exclude injuries arising out of, quote, employment-related practices, policies, acts, or omissions such as coercion, demotion, evaluation, reassignment, discipline, defamation, harassment, humiliation, or discrimination directed at that person. So Bertle was employed by the Showerman defendants when this allegedly happened. She was performing as an employee when the acts occurred. The defendant Todd Showerman was displeased with what she was doing and how she was doing it, and he allegedly engaged in certain acts, discrimination, harassment, humiliation, or discrimination, directed towards Ms. Bertle. And that falls under the employment-related practices exclusion. There is also count 7, defamation. This is alleged to be defamation of Ms. Bertle by the defendant Christine Showerman, and it is directly related to employment and the alleged statements about the employer. And that, as well as an act of defamation, falls under the employment-related practices exclusion. The defendant, Christine Showerman, says there's an issue of fact as to whether she knew her statements were false or were simply made negligently. Well, the employment-related practices exclusion covers defamation without distinction, but also negligent defamation under MCL 600.2911 subparagraph 7 allows for economic damages only. So if she's claiming negligent defamation, that involves economic damages only, and that's not property damage covered under the policy. Furthermore, again, this issue comes up again, that Christine Showerman has to do more than just assert that there's an issue of fact about that. Where is the support for that in evidence such as an affidavit? So the employment-related practices also applies to counts 8 through I'm going to say 10, possibly even 11, but I'll discuss 11 in a moment. But those counts also don't come under coverage for another reason, and that is, again, coverage only applies to damages because of bodily injury or property damage. Bodily injury means bodily injury, sickness, or disease sustained by a person, including mental anguish, mental injury, shock, fright, or death resulting from any of these at any time. Property damage means physical injury to tangible property, including all resulting loss of use of that property. I'm leaving out some of the parts, or B, loss of use of tangible property that is not physically injured. All such loss of use shall be deemed to occur at the time of the occurrence that caused it. These counts seek back wages, that's counts 8 and 9, and access to Ms. Bertle's employment file, and that's count 10. These are purely economic losses, and they cannot and do not constitute property damage as that is defined in the policy. And that takes us to count 11, a claim under the Elliott Larson Civil Rights Act that also seeks economic damages. It's not a claim for property damage. It does also seek damages, I acknowledge this, for mental and emotional distress, but that doesn't bring it under coverage. The mental and emotional distress is alleged as the result of employment discrimination. Bodily injury under the policy includes mental anguish only as it results from bodily injury, sickness, or disease, not as it results from employment discrimination. So none of the counts of the underlying lawsuit, counts 1 through 11, even arguably come within the policy coverage. They also, even if they did, which they don't, come under various different exclusions under the policy. And consequently, there is no duty by the plaintiff to defend or indemnify under the policy. And I am granting the plaintiff's motion for summary disposition as well as the plaintiff's full requested relief, including the repayment of the defense expenses. And Mr. Ryan, do you want to submit an order, or do you have an order?
I neglected to bring one. I'll submit one, Judge.
Okay, you can just say for the reasons stated on the record.
Well, yeah.
Okay, then that will conclude our hearing.
Thank you, Judge.